Hi, welcome back to Securities Regulation. This is Lecture 10, which defines the securities market and its regulation. Now, before we get into the regulation of securities and their markets, it might be helpful to define what is a securities market. A securities market is nothing but a physical or a virtual location where buyers and sellers can trade in securities. Now, what is a security? A security is usually a financial product that is based on either the price of shares or on the price of debt or on the price of commodities or currencies. Now, for the purposes of our course, we'll be focusing only on shares, right? So whatever applies to shares applies pretty much to any other financial security or financial product. Now, there are a number of entities that offer to sell financial products or shares, primarily amongst which are companies. However, selling shareholders of companies, perhaps promoters or other institutional shareholders, may also sell their shares on the securities market. In addition, you may have mutual funds who offer, mutual fund units or other derivative securities onto the securities market. Who buys these? Well, primarily it's investors like you and me. We would be called as retail investors, while you may have certain high net worth individuals who are also buying and trading in these securities. And of course, you'd have qualified institutional buyers, which are primarily financial institutions that trade in these securities as well. We'll talk more about the kinds of investors or the kinds of buyers in a securities market later on. One point that you must note is that when a company or a selling shareholder or a mutual fund is offering its shares or securities for the first time, this is known as a primary market. And once these shares have been sold onto the primary market, any further trade of these shares, the kind of trades that happen on a regular basis in a stock exchange, those are known as a secondary market. Both of these together constitute the securities market. Now, to help buyers and sellers come together to understand what the securities are, what the price is, and to ensure that there is a smooth transaction that takes place, there will be a number of intermediaries. Intermediaries are entities that help support and grow the securities market. These intermediaries would include merchant banks, auditors, brokers, clearinghouses, depositories, so on and so forth. And overseeing this entire operation, this entire ecosystem, is a regulator known as SEBI, the Securities Board of India, Securities and Exchange Board of India. So how do securities regulators regulate securities markets? Now, these are principles that exist across the world. First, they use eligibility criteria. What kinds of companies can issue shares on the securities market? Second, when they do so, if they are able to do so, what kind of disclosures or what kind of information must be presented to the securities market before these shares are listed? After these shares are listed, what kind of disclosures are to be made on a regular, continuous basis? And of course, there is a well-defined procedure, well-defined process under the issue of capital and disclosure requirements regulations, which guides us as to how a company may issue shares to the market. Using these three mechanisms, eligibility criteria, disclosures, and a well-defined process, SEBI regulates the securities market. Now, let's take a look at Regulation 5 of the ICDR. When we turn to Regulation 5, we note that there's a well-defined eligibility criteria, a negative criteria, which if a company meets, then they're not allowed to access the securities market. They're not allowed to issue shares to the public. Let's take a look at Regulation 5. An issuer shall not be eligible to make an initial public offer if the issuer or any of its promoters or promoter group or directors or selling shareholders are debarred from accessing the capital market by the board. Board over here refers to the Securities and Exchange Board of India. Or if any of the promoters of the director is a promoter or director of any other company which is debarred from accessing capital markets. Or if the issuer or any of its promoters is a willful defaulter or a fugitive economic offender. So in this case, we see that there are a number of negative criteria which, if a company meets, then they would not be allowed to access the capital markets. We note that in Regulation 6, there are a number of further eligibility requirements that need to be met by a company before making an initial public offering. We'll look at this particular regulation at a later stage. For now, it is enough for us to know that SEBI has certain negative eligibility criteria and positive eligibility criteria for a company to meet the threshold to make an initial public offering. Once it chooses to do so, it must disclose information about itself to the market, and it must carry out a well-defined process. Now, when we come to the disclosure of information about a company issuing its shares, who should be responsible for that disclosure of information? We know that shares are goods, but it would, and therefore caveat emptor does apply. However, it would be pretty much impossible for the public capital markets to conduct a diligence on every company that is coming up for an IPO. In other words, if we are going forth for an IPO, it is upon the company to disclose information about itself to the potential investors, to the capital markets. The role of these disclosures is that, or how these disclosures help, is that they reduce information asymmetry between the company that knows everything about itself and potential investors who may know nothing about the company. Second, it helps us arrive at a fair price of shares, where, depending upon the information disclosed by the company, we may compare it with its competitors in the market and arrive at a fair price for these shares. And third, it allows investors to make a well-informed decision as to whether or not they would like to invest in this company. So, if there is enough information available about a company in the market, potential shareholders and potential investors will be able to make a decision as to whether or not they'd like to invest in this company. Where are these disclosures placed? Well, we've all heard of the term, the offer document. Mutual fund investments are subject to market risks. Please read the offer document carefully before investing. This offer document is generic to all transactions that take place on the capital markets. The offer document contains all the disclosures that a company needs to make when issuing shares or doing any other kind of a transaction on capital markets. Now, for different transactions, this offer document is given different names. It could be called a red herring prospectus in the case of a public offering of shares, whether it's an initial public offering, IPO, or a further public offering or an FPO. It could be called a letter of offer in the case of a takeover. It could be called a placement document in case of a qualified institutional placement, right? So this offer document is a document which contains all of these disclosures that a company will need to make. Now, how are disclosures regulated? Well, there are two sets of regulations that apply to disclosures made in the pursuance of a public offering. The first of these regulations, or the first of these, or set of these provisions, is found in the Companies Act 2013, where we see that Section 23, Section 25, Section 26, 34, and 35 give us some idea as to what must go into a prospectus. Section 23 says that if a company is offering securities as part of a public offer, then it must do so through a prospectus. What is a prospectus? That is answered by Section 25. A prospectus is nothing but, as we mentioned earlier, the offer document which contains all the disclosures and the offer to sell shares to the public market. Section 26 gives us a brief overview of what a prospectus must contain. Now, this is superseded in a way by the SEBI ICDR regulations, and we'll be studying what needs to go into a prospectus, not by studying the ICDR, but by studying a real life prospectus. And of course, there is criminal and civil liability for misstatements or misrepresentations made in a prospectus. In other words, the offer document that is prepared by the company must be prepared in a manner that is verifiable and accurate. If there are any misstatements or misrepresentations, people can go to jail. However, most of the disclosures that go into a prospectus or an offer document are covered under the SEBI ICDR regulations. If you take a look at Schedule 6 Part A of the ICDR, this gives us general guidelines as to what needs to be put into a prospectus. To begin with, all information about the company that is relevant must be put in, right? This information must be updated and substantiated, which means that there must be some backing evidence or some backing proof for all the information that goes into a prospectus. Simple English needs to be used. We can't use English that is too technical. Remember, you're making an offer document that should be easily read by the common person. SEBI places a lot of emphasis on cross-referencing and consistency. What this means is that if I am referring to a particular event in the company in two different places of the prospectus, I must refer to each of these two places whenever I am referring to this event, right? So for example, if let's say a particular director is under investigation for some economic offense, which is not a big deal, it's just under investigation, no charge sheet has been filed, but this would come up as a risk factor, which means that when I'm describing the risk factors of the company, I must cross-reference it to the place in the directors chapter where we are talking about this particular investigation against the director. We'll come to what is a risk factor in a bit, right? All right. So what is a risk factor? Risk factors are the most important part of the offer document. They usually take up one of the first few chapters of any offer document. So any information that has an adverse effect on the issuer, on the company, is a risk factor. Now, this could be a litigation against the company. This could be the lack of a particular permit or license. This could be an adverse effect in the industry within which the issuer is operating. It could be something which is affecting the business operations of the company, any labor unrest, so on and so forth. Risk factors could either be external, which the company has no control over, or internal, something that the company can fix at a later date. Materiality is important when it comes to risk factors. Now, risk factors could be material when taken on its own. So for example, a litigation against the promoter is a material information which is adverse to the company, or a substantially high number of litigations against the company, each of which are small in nature, but together they combine to become a fairly substantial or material adverse effect, could also become a risk factor. For example, if a company manufactures FMCGs, fast-moving consumer goods, and there is a high level of consumer dissatisfaction and a high number of consumer cases against the company, then together all of those cases, which could be individually very small in nature, but together they might have a substantial effect on the company, right? Risk factors could be qualitative as well as quantitative, right? What this means is that risk factors may talk about the quality of certain things in the company, or the quality of, let's say, directors and their backgrounds in the company, or they might talk about the financial aspects of the company as well, let's say dwindling profits or dwindling revenues over the years. Risk factors may not be material on a particular date, but if the company is far-sighted enough, it might actually take into account information that will be material later on and might turn into a risk later on as well. For example, in a company which is heavily dependent upon agricultural produce, one of the risk factors, an external risk factor, could be the performance of the monsoon. Now, we don't really know which years are going to have good monsoons and which years are not going to have good monsoons. As a result, the seasonality of India and the advent of the monsoons and our dependency, our agricultural dependency on monsoons, could be material at a later date. So when drafting a risk factor, how do we go about it? What are the ingredients of a risk factor? Well, in a risk factor, we need to first identify the problem or the potential problem. So we state what the problem is. Then we add what the management could be doing with this problem. What is the management going to do about this problem, or what steps has the management already taken as part of this problem? So the risk factors are one of the most important chapters in the draft red herring prospectus or the red herring prospectus. There are a number of chapters that go into the red herring prospectus, right? Now we'll go over these chapters very, very quickly, but of course we'll do a detailed analysis and a detailed breakdown of the red herring prospectus at a later stage. So effectively, the red herring prospectus contains an introductory chapter which contains a summary of the industry within which the company operates, a summary of the business, its strengths and strategies of the company, financial information, information about the issue of shares, how many shares are being issued, what rights do they carry, at what price will they be issued, so on and so forth, general information about the company and its advisors, and the capital structure of the company. There are a number of other chapters which we as capital markets lawyers are concerned about. This includes the particulars of the issue, which is the objects. For what purpose is this company going to issue shares and it's going to get money? So what is the purpose of getting that money? How are they going to use it? What is the basis of the issue price? How did the company come to this issue price? And a statement of tax benefits. Now, these three chapters or these three sections aren't particularly of much interest to capital markets lawyers, because this is information that is typically vetted by the merchant bank and provided by the company itself. Similarly, the company provides more information about itself as part of the industry overview, the industry under which it operates, the business which is undertaken by the company, key industry regulations and policies that apply to the company. Now, this is something that capital markets lawyers are involved with in drafting. History and other corporate matters, again, a chapter which we as capital markets lawyers have to draft. Similarly, our management, information about the promoters and group entities, and the policy of the company as to its dividend, right? We also have a section on financial information, which is very, very important, which includes the financial statements, a discussion of the management and an analysis of the financial condition and the financial health of the company, as well as a statement of the financial indebtedness of the company, or what are the debts that the company has taken on. Finally, we have a few sections that deal with the legal information pertaining to the company. This includes all the litigation that has been carried out or is pending before various courts against the company, approvals that the company has had to take for its own business and the issue of shares, other regulatory and statutory disclosures, the structure of the issue. Now, this is the actual offer of shares to be made and under what terms it is to be made. We also have a section on the Articles of Association, which basically talks about the rights and obligations of shareholders. Now, mind you, the reason why we put this in is that the Articles of Association, talks about the rights and obligations of shareholders, and we're offering shares to the public, and therefore they will be subject to the rights and obligations of this Articles of Association. And of course, you'll have some material contracts which are important to the company, some substantial agreements depending upon what kind of company we have and what kind of business it runs, and finally a declaration saying that everything that has been stated in the offer document is true. Of course, this is where the criminal and civil liability comes in. If this declaration is made untruthfully, then, well, people go to jail. So this has been an overview of the securities market. We have defined what the securities market is. We figured out how SEBI regulates the Indian securities market, primarily through entry barriers or entry level barriers, eligibility criteria, through disclosures, and through an ongoing process. We've talked about disclosures in some minute detail here. We've talked about what kind of disclosures go into a red herring prospectus. In further lectures, we'll talk about what the process is, and we'll get into further details as to eligibility criteria as well as the entire process of the IPO.